Christiana, you asked Jay to hold money on trust for you. You did that because you took the view that you were not good with money. Now, ordinarily, that's a sensible thing to do, and there's nothing wrong with it. What's more, once you do that, Jay is under an obligation to protect that money. She has what's called in law a fiduciary responsibility to protect it, to make sure it's safe, and when you want it, to give it back to you.
Yes.
The problem is neither of you took a record. And so I have to firstly determine exactly how much money is owing. The view that I would automatically take is what you first asked for when the relationship broke down, because that gives me the sense of what you believed she had left.
Yes.
The first amount that you asked for was £120, and consequently, if this case only included that application, I would have awarded you £120 with no difficulty, on the view that Jay had been in breach of her fiduciary duty to keep this money on trust on your behalf. However, in January, you sent a text message saying, "I've thrown your stuff away in exchange for my money." In law, that means the debt is satisfied. Because you expressed that, madam, you are no longer entitled to claim anything. And therefore, I dismiss your application in its entirety. I can't wake up in the morning and say, "I want to copyright this wonderful thing I've just invented. They're marvellous, and what's more, they keep you regular. They're called cornflakes." However, I could, if I wanted to, copyright, well, Michelle could, Michelle's cornflakes, which are a certain flavour, a certain size, and they give you an uncanny ability to stand up in heels for 12 hours a day, for example. It's an idea. That would be a reasonable thing to copyright because it relates to her, it's her intellectual property, and it's unique. Part of the bargain you had was that the car you were buying was for spares and repairs. In other words, Steve says as part of his defence, he made it perfectly clear that you would not be entitled to any of your statutory protections because you were buying a wreck. And consequently, Steve provided a document. Steve, you did exactly the right thing in theory by drawing together a legal document saying very clearly you are taking away a car for which I have no responsibility. And the reason I have no responsibility is because it's for spares and repairs. And you provided this document. The difficulty, sir, is this document only covers unroadworthy vehicles. This document does not remove Ian's rights as a consumer. The reason I know that is because it specifically states, I understand that my statutory rights are not affected. What's more, as you'll recall during the course of the case, it's very clear that all of the other references in this document relate to the type of vehicle which shouldn't be on the road in the first place. That could never be the case in respect of this car because, amongst other things, it had an MOT. Consequently, this document is not valid. You are entitled to sell a car for spares and repairs. And you're entitled to tell somebody that they don't have a warranty and it's their problem. But if you do that, you need a better legal document than this, I'm afraid, sir. Because you are still entitled to your statutory obligations, you are consequently entitled to the full cost of the value of the repairs, which in this case is £2,060. Sir, you may run a perfectly valid business despite that porky. You need to get this document updated. It seems to me, Jackie, that you're entitled to be compensated for the damage to those pansies, which is £75. However, after that time, as a matter of law, you were on clear notice that there was a substantial risk that bringing a goat into your property would cause damage to the pub. And consequently, according to the relevant law, I'm unable to do anything because there is an exception where you have voluntarily accepted a risk by bringing a goat into your business. Consequently, any of the other damage, the carpet, the radiators, etc., as a matter of law, despite his assurances, are, as a matter of law, your fault. And so there's nothing I can do about it, despite wanting to help. Consequently, this court can only award you the sum of £75 for the first amount of damage that was caused and advise you in the strongest possible terms to put a very big note on the front of your pub saying no goats allowed, especially Eric. I'm afraid I have to dismiss the rest of your case. Thank you for bringing Eric. The award of this court is £75. You bought a coat for £15. I'm satisfied, based on the evidence I've heard from Dina, that they sold you that coat at a loss. I'm equally satisfied that she did that not in her best commercial interest, but because, for whatever reason, and it was to do with your health, she felt sorry for you. I'm certainly satisfied there weren't 2 adverts. That's absolutely clear. Both Dina and her partner, her very honest partner who comes to court today, came to your flat and went out of their way in circumstances where they didn't need to deliver that coat to you. At the time they delivered that coat to you, it was up to you, in law, to try that coat on. In the circumstances here, I'm satisfied that after you'd bought the coat, you came to a subsequent arrangement with Dina for your money back. In other words, they had accepted that they would return the money, and that created, in effect, a new agreement for your money to be returned, which you relied upon.
Yes.
And therefore... Well, thank you.
Sorry.
And therefore, in the circumstances, very narrowly, although I find you didn't try it on and you should have done, and it would be your responsibility ordinarily, I do find, to that extent, theoretically, they owe you £15. £15, not the biggest case in the world, but a matter of principle for you.
It is.
However, I'm very alarmed indeed, that you appear to have posted on a public site something about these 2 young people who are trying to run a business, which on the face of it is untrue. And as a result, they've suffered some kind of loss. Now, it's impossible for me, without any evidence, to come to an assessment of the value of that loss. But I certainly find it's worth the value of a coat, £15. And therefore, your counterclaim for defamation, certainly as far as the value goes, of £5,000 is dismissed. But it's upheld in principle, insofar as I do find that Debbie posted something which was untrue, and she shouldn't have done. Your claim is successful, insofar as you're awarded £15, and you're awarded £15, which means you both have to receive £15. But give the coat back. That's the award of this court. Can you tell me the date of this contract, please? What year was it, please?
2008.
2008?
Yeah.
That's when you entered into the agreement?
Yeah.
I see. Oh, dear. Junior, Stephen, you had a clear contract with Stephen for rent, and it was quite clear to me that he owed you for the entirety of the rent, which was £1,680. Until seconds ago, I would have awarded you the entire value of that claim with very little difficulty whatsoever. The difficulty is in law. Just as you have to get rid of people within a reasonable period of time, sadly, in contract law, you have to bring your claim within 6 years. Your application in this case is way outside of that period, so I have no choice but to dismiss your claim. Very sad. That's the award of this court. Michelle.
Yes.
I bet you that you can confidently predict the outcome of this case. If you're right, I will buy you lunch. Let's certify it. Now, whisper to me how you think it's going to go. Do you think he's going to win or he's going to win? Just whisper to me.
I think Lucas is going to win.
Do you?
Yes.
Oh, dear. Thank you very much, Michelle. Now, Michelle and I have just made a bet, and interesting who she's betting on.
Yeah.
Assuming she's right, is that a legally enforceable agreement?
Yes.
Is it? These cases happen all the time. Why aren't they in the courts all the time?
Why don't people take them to the courts? That's something for the people to decide. They should, if they want to do it, then they should get off and go and initiate something and take a case to themselves.
Sadly not. It's a very interesting matter. Is there anything you'd like to reply? Would you like to make a legal submission and reply, Eddie? Would you like to say there is something in this country called lawful betting, and that takes place under law, under the Gaming Act? In betting shops, for example, and yes, that's changed recently, by the way, If a betting shop doesn't pay out, I've got a contract with the betting shop because that's what the law tells me. But gambling between individuals is not lawful. And I can't go to court and seek relief from a judge on a contract when the agreement is not a lawful agreement.
Yeah,
why do you say that a betting agreement is a lawful agreement?
A betting agreement is a lawful agreement because I'm offering Eddie something and Eddie offered me something in turn or something happening, both in exchange, and there was a handshake to it. So therefore, I would see it as a contract. But,
you would?
Yeah, most definitely.
But the law wouldn't.
OK, I did.
Who do you think wins? Imagine it's you and the MMA fighter. Who wins between you and the law?
Between me and the law, then the law.
Yes. You know that song, I fought the law and the law won?
Yeah. Well, no.
It's a very interesting matter. And sadly for you, and I have to say, rather more sadly for Michelle, bearing in mind what she promised me if I won the bet. Don't be stupid. Stay and watch the best Judge Rinder moments. And I'm talking. Understood? Don't be a moron. Subscribe to Judge Rinder YouTube channel. Right now. That's an order.